Section 4. The Parol Evidence Rule and the Danger of Side Agreements. That's not what David told us. A few days have passed since Ashley spoke with her designated broker, Michael, about David's financial situation. Michael has asked Ashley to gather more information about the property, including the mortgage payoff and any additional liens that might affect the sale. Meanwhile, Marcus and Elena are continuing through their purchase as if everything is normal. Then Daniel receives another call. This time it's Elena. Daniel, I was looking through the contract again. Where does it say David is leaving the backyard spa? Daniel stops. The spa? Elena reminds him of a conversation from the second showing. Marcus and Elena were standing with David in the backyard, admiring the built-in patio and large portable spa. According to Elena, David said, "We're moving into something smaller. I'm not taking that thing with me." Elena interpreted that statement to mean the spa was staying. David remembers saying something similar, but his interpretation is completely different. He says he meant that he would sell the spa separately before moving. Now Elena says the sentence that every experienced real estate broker has heard, but that's not what he told us. Welcome to another contract problem. The written contract matters. The parole evidence rule sounds like something designed to make a contract law exam difficult, but the basic concept is practical. When parties negotiate a transaction, they may have numerous conversations before reaching their final agreement. They make suggestions, reject terms, discuss possibilities, send messages, and sometimes say things they later remember differently. Eventually, they reduce their agreement to a final written contract. As a general contract principle, prior or contemporaneous oral statements cannot simply be used to contradict the terms of an integrated final written agreement. Why? Because if every prior conversation could automatically override the final written contract, a written contract would lose much of its purpose. Imagine trying to close David's transaction if Marcus says, "David told me the spa stays." Elena says, "He also mentioned the patio furniture." And David responds, "I never agreed to either of those things." The contract should tell us what the parties agreed to. But Arizona's rule has some important nuance. Here's where we need to be careful. It would be tempting to teach the parole evidence rule by saying, if it isn't in the contract, a court can never look at it. That's too broad. Arizona takes a more nuanced approach to extrinsic evidence when interpreting contracts. In Taylor v. State Farm Mutual Automobile Insurance Co., the Arizona Supreme Court explained an approach allowing a court to consider evidence offered to determine the meaning intended by the parties, while still limiting evidence that would actually contradict or vary the meaning of the written agreement. For an Arizona real estate agent, you do not need to become an expert in evidentiary law. You need to understand the practical lesson. Do not create a transaction that requires a judge to figure out what your clients meant. If the spa matters, address the spa. If a refrigerator matters, address the refrigerator. If a $5,000 credit matters, document the $5,000 credit. If the closing date changes, document the closing date. The cleaner the contract file, the fewer mysteries everyone has to solve later. Side agreements can become major problems. Let's make the situation more serious. Suppose David quietly tells Marcus, "Put the purchase price at $518,000, but after closing, I'll give you $10,000 back privately." Marcus thinks he's getting a great deal. Daniel learns about the arrangement. Should Daniel simply say, "That's between you guys"? Absolutely not. Undisclosed side agreements can affect lenders, escrow, settlement figures, underwriting, and other parties relying on the transaction documents. Depending on the circumstances, they can create serious contractual, lending, disclosure, regulatory, or even fraud concerns. A real estate licensee should never help create one version of a transaction for the official file, while knowing the parties have a different, undisclosed agreement on the side. AAC R428-1101 establishes duties Arizona licensees owe in protecting clients and dealing with transaction issues. And ARS Section 32-2153 provides grounds for disciplinary action in numerous circumstances involving improper conduct. This is something agents need to take seriously. What should Daniel do about the spa? Daniel doesn't tell Elena, "You're definitely entitled to it." He also doesn't say, "Too bad it's not written down so you automatically lose." Both statements could become legal conclusions that depend on the contract language and surrounding facts. Instead, Daniel reviews the written documents, discusses the issue with his broker, and communicates with Ashley about whether the parties can reach a clear written resolution. That's what good transaction management looks like. Agents don't have to personally decide every legal question. They need to recognize when a question exists. Then, Michael calls with bad news. While Daniel and Ashley are working through the spa issue, Michael receives information concerning David's property. The numbers aren't what David expected. Between the first mortgage, another lien, missed payments, potential fees, closing expenses, and the costs associated with selling the property, David's expected equity is disappearing quickly. Michael calls Ashley. We need to sit down with David. Ashley asks, how bad is it? Michael pauses. If these numbers are right, David may not be able to sell this property and pay everything that's owed without bringing money to closing. For the first time, Ashley hears the phrase that will change this transaction. We may be looking at a short sale. And suddenly, everything we've learned in Chapter 1 matters. There is a contract, there are buyers, there is a seller, there are contractual obligations, but now there may not be enough money to satisfy the debts against the property through an ordinary closing. Chapter 1 taught us how contracts are created and documented. Chapter 2 will show us what happens when the parties actually have to perform. 1. Elena says David verbally promised that the backyard spa would remain with the property. But the final written documents do not clearly reflect that promise. What should Daniel do? Answer. Daniel should review the written transaction documents, involve his broker as appropriate, and communicate with the listing side about resolving the issue through clear written documentation if the parties can reach an agreement. He should avoid making a definitive legal determination about ownership or enforceability when the parties dispute what was promised. 2. Why is it inaccurate to say that the parole evidence rule means a court can never consider information outside the written contract? Answer. Because the parole evidence rule generally does not mean that a court can never consider outside information. The rule prevents evidence that contradicts the written contract, but it often allows for evidence that explains or supplements it, as long as it doesn't contradict or alter the finalized terms. Arizona follows a more nuanced approach. Extrinsic evidence may sometimes be considered to determine the meaning of contractual language and the party's intent, but it cannot simply be used to rewrite the agreement or contradict its written terms. Taylor versus State Farm is an important Arizona authority concerning this approach to contract interpretation. 3. Why can an undisclosed side agreement create a serious problem in a real estate transaction? Answer. Other parties may rely on the official transaction documents, including lenders, escrow companies, title companies, and brokers. An undisclosed agreement that changes the true financial or contractual arrangement can create significant contract, disclosure, lending, regulatory, or fraud concerns. Agents should never knowingly help parties maintain one transaction in the official documents while secretly operating under another arrangement.